And this is one of the most overlooked advantages of a trust-based plan. A flexible plan is not just about what is written today, it's about how easy it is to change tomorrow. If your plan is built around beneficiary designations, every change requires updating multiple accounts. That means dealing with different institutions, different forms, and different processes. In many cases, you're making dozens of updates, but it only takes one missed account for the plan to become inconsistent. When people hear about estate planning, most of the focus is on what happens when you pass away. But in reality, the biggest risk to your estate plan isn't death, it's change. Laws change, family dynamics change, assets change, and health changes. A plan that looks perfectly fine today can break down completely in 5 or 10 years if it is not built to adapt. That is why the idea of flexible estate planning is becoming more important. If you want a plan that actually works when your family needs it, it has to be able to respond to real life, not just a set of assumptions that may or may not hold true in the future. The first place this starts is with structure. A properly designed estate plan should be built around a revocable living trust, not a collection of disconnected documents or beneficiary designations. A well-drafted trust acts as the central control system for everything. Instead of having instructions scattered across multiple accounts at different institutions, everything flows through one coordinated framework. That allows you to control how assets are distributed, when beneficiaries receive them, and under what conditions, all in one place. In a properly structured system, all of the beneficiary planning happens inside the trust. That is where the real decisions are made. If you want to change who receives what, adjust percentages, or add contingencies, you're making those changes in one document. You're not chasing down multiple accounts and trying to update forms across different institutions and running yourself ragged. The trust becomes the single source for truth and how your assets are ultimately handled. This is also why your will should not be doing any real distribution planning. In a well-coordinated plan, the will acts as a safety net. Its job is to direct any assets that end up going through probate into the trust. In other words, the will is not where your plan lives. The trust is. The will simply makes sure that everything gets back into that system so your plan can still be carried out as intended. Probate attorneys don't like this information getting out because it makes people wonder whether probate really is a big deal or not. If this sounds different from what you were told, please leave a comment. And if you want more straight answers, like and subscribe. When you take this approach, the trust becomes the hub of your entire estate plan. Most, if not all of your assets are either owned by the trust or point to the trust as the beneficiary. That consolidation creates clarity and consistency because everything is governed by one coordinated set of instructions instead of multiple independent forms. The second key element of flexibility is how distributions are handled. Your plan should include meaningful trustee discretion with clear guardrails, not rigid one-size-fits-all instructions. Many older plans lock distributions into fixed ages, like a third at 25, the rest at 30. That sounds simple, but it removes the ability to respond to real-world situations. At the same time, you don't want unlimited discretion with no structure. A well-designed plan strikes a balance. It allows the trustee to consider factors like maturity, financial responsibility, creditor exposure, divorce risk, or substance abuse concerns, while still working toward a final distribution age, often around 40. The reason is straightforward. By that point, if a beneficiary has not developed financial responsibility, continuing to hold assets back indefinitely is unlikely to fix that problem. Even after that final distribution age, however, the plan should still be able to provide protection if it's actually needed. If a beneficiary is dealing with disability, lawsuits, or financial distress, the trust can continue to hold and protect those assets instead of distributing them outright. This is what real flexibility looks like. It adapts to the situation without losing structure. A third element is layered contingency planning, and this is where many estate plans fail. Most plans assume a straight line. Assets go from you to your beneficiaries, and that's it, end of story. But real life rarely works that way. One of the most overlooked realities is that about 1 in 6 couples will experience the death of a child before they pass away. It is an uncomfortable possibility, but it is not rare and it needs to be planned for. When that contingency is not addressed, the results can be severe. If a beneficiary is no longer living, where does their share go? Does it pass to their children? Does it get redistributed? What happens if those grandchildren are minors? These are common situations that require deliberate planning and not assumptions. This is also where relying on pay on death beneficiary designations becomes dangerous. Those forms are extremely limited. They might allow for a primary beneficiary and one backup, but they do not handle complex situations. They do not have age limitations. They do not have protection for disability. They do not adapt. They simply follow the form. I have seen firsthand how badly this can go. There was a couple who died in a car accident when their daughter was just a few months away from turning 18. Because everything was set up using beneficiary designations, she inherited an investment account worth about $1.2 million outright. There were no protections, no stage distributions, no oversight, none of it. The result was exactly what you would expect when someone that young receives that kind of money. She dropped out of high school, married a 25-year-old unemployed man, and spent about 80% of the inheritance on a house she could not realistically afford to maintain. Even after the majority of the money was gone, she believed she would never have to work a day in her life. That outcome was not intentional. It was the result of a plan that did not account for real-world contingencies. A properly drafted trust could have held those assets, supported her education, and protected her from making irreversible decisions at that stage in her life. The fourth element is building in beneficiary protection options, even if you are not sure they will ever be needed. A flexible trust is not static. It can adjust based on what is happening if a beneficiary's life has something that comes up. That means if a beneficiary later becomes disabled, goes through a divorce, or faces creditor issues, the trust can shift to protect those assets instead of distributing them outright. I saw this play out with 2 different clients who came into my office within the same month. Both were widows, and both had adult sons who suddenly became disabled. In one case, the son suffered a brain injury in a car accident and never fully recovered. In the other, the son was injured in a construction accident, went on disability, but eventually recovered after a few years. In both situations, the concern was the same. What happens if the son received an inheritance while on disability or Medicaid? Would they lose their benefits? Would they have to spend everything down? And in both cases, I was able to give the same answer. There's nothing to worry about because this was already accounted for in their trust. The plan was designed to be flexible from the beginning. That meant the trustee could hold and manage the assets in a way that preserved benefits while still providing support. In the case where the son recovered, the plan could adjust again without being locked into a permanent restriction. That's the difference between a rigid plan and a flexible one. A rigid plan forces an all or nothing outcome. A flexible plan allows that situation to be evaluated and handled appropriately in real time by the trustee. The fifth element is ease of modification. And this is one of the most overlooked advantages of a trust-based plan. A flexible plan is not just about what is written today. It's about how easy it is to change tomorrow. If your plan is built around beneficiary designations, every change requires updating multiple accounts. That means dealing with different institutions, different forms, and different processes. In many cases, you're making dozens of updates, but it only takes one missed account for the plan to become inconsistent. When your plan is built around a revocable living trust, you make the change once inside the trust, and everything else remains coordinated. The trust acts as the central control system. Whether assets are owned by the trust or point to it as a beneficiary, the instructions all come from one place. This also makes it much easier to handle new assets. When you open a new account or purchase property, you're not trying to figure out how it fits into a scattered system. You already have a structure in place. The assets can be titled in the trust or directed to the trust, and it becomes a part of the overall plan immediately. When you step back and look at all of this, flexibility in estate planning comes down to one idea. Your plan should be able to adapt to circumstances you cannot predict today. The goal is not to guess every possible outcome. The goal is to build a structure that can respond intelligently when life inevitably does not go according to plan. If you want a clear step by step explanation of how to build an estate plan that actually works the way you intend, you can start with my free course at freetrustcourse.com. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.